a statutory claim based under Texas law, what we call the Vested Rights Act, some state constitutional claims, and more significantly, some federal constitutional claims. A claim of denial of equal protection of the laws, saying that they were being treated differently than other developers under the city's driveway permit ordinance, and also a claim for denial of substantive due process, translated meaning that the city acted arbitrarily or capriciously in denying the April 4 application based on a traffic impact analysis, pointing to evidence that at one point in time the city had approved that analysis and concluded that there would be no adverse impact on the traffic on Bissonnette near the project. As I indicated earlier, we then retained Fulbright and Jaworski, and on September 18, 2011, Judge Rosenthal issued her order with respect to our motions to dismiss, which she granted in part and denied in part. Now, this was a very significant juncture in the case. Judge Rosenthal reasoned that the claims asserted by the developer based on a denial of equal protection of the laws, that is, that the city allegedly treated this developer different than similarly situated developers, and the claim of denial of substantive due process. In both instances, the court found that the case should proceed on those claims. In short order, we were also contacted by the counsel for the developer, who made an initial settlement overture to the city. So we had at that point a threshold decision to make from a legal standpoint. We still had to designate experts to testify in the case. We still had to take expert depositions. And one of the experts that the plaintiff's counsel had identified was the individual who was employed by the city back in 2007, September of 2007, who wrote the letter stating approval of the traffic impact analysis that had been conducted by the developer, and stating further that this project would have no adverse impact on traffic on Bissonnette. That individual was going to be an expert witness against the city. We also concluded, of course, that the appropriate step then going forward, if we were going to proceed with the case, would be to file what we call a motion for summary judgment, where we present evidence to the court for the first time for it to consider, something beyond just the pleadings filed by the parties. Let the court look at that evidence and see if the city was entitled to judgment as a matter of law. I recognize, though, at that juncture that if we did not prevail on a motion for summary judgment, our chances of settling this case in a manner that would be favorable to the city would be diminished considerably, because we would have rolled the initial dice and lost. I also knew, having had many years of trial experience, that if this motion for summary judgment was denied by the court, then we would be proceeding to trial in the Southern District of Texas, Houston Division. And we would have a jury composed of individuals coming from 13 different counties, 12 in addition to Harris, counties like Waller and Wharton and Grimes and Austin, that might have a lot of difficulty identifying with the kind of issues that we confront in this case. And there's one thing I can assure you, is that if we had to pick a jury, unfortunately, none of you would have been able to serve, because you obviously would have been prejudiced in the case. And I had to ask myself at that point in time, even if we did prevail on the summary judgment motion, what would we have won? Would we really have won anything? Remember, as this timeline shows, back on August 25th, 2009, the city approved a plan for the Ashby Highrise, a 23-story high-rise at 1717 Bissonnette. The best outcome we could have achieved in this case is that that high-rise would be built. So even if we had won, in quotes, what would we have won? And if we lost, what would we lose? Well, for one thing, the city could have been ordered to grant the permit or grant the application that was originally submitted by the developer in April of 2009, which was for a much larger project. In the alternative, if the city lost, it could have been hit with an award of damages, perhaps as much as what the developer claimed it had been damaged, based on the difference in value between the project that they had wanted to build and the value of the project that the city had approved. I couldn't think of two worse results: that they would be able to build the larger project, or that we would have actually had the taxpayers finance the building of the project that had been approved in August of 2009. Having tried many cases myself, I know that every trial lawyer who has a case where there's some exposure for his client reaches a moment of truth where you have to honestly and candidly assess the risks on both sides. I talked with Fulbright and Jaworski extensively about this. I talked with community representatives about this. You notice the date of October 11th, October 11th, 2011, when I had a meeting with community representatives and Council Member Clutterbuck to brief them on the status of the litigation and the settlement overture. And obviously, I talked at great length with the mayor at that point in time. And what I kept thinking of was, what are our choices here? A hollow victory, so that this 23-story high-rise is still built, even if we win, or a disastrous result, where the larger project could be built, or the 2009 approved project could be built with taxpayer money. And I had to ask myself at that juncture, is there a middle ground for this? Is there something that can be done? Can we make this project less undesirable? Admittedly, there are no good choices here. But I was wondering if perhaps we could find the lesser of the evils. So in consultation with all the lawyers on the defense team, where I was being encouraged by them to sit down and discuss settlement, one thing I laid out as being a clear prerequisite, that I would not sit down with the attorneys for the developer if they were expecting that the city would provide any money on this case, because I felt that if we were to settle the case and pay any money, that we would in that manner, also be financing this project. One thing the developer's lawyers made very clear: this project would be built one way or the other. And after, I needed her or him on my legal team as well. After weeks of telling the lawyers for the developer that there would be no money, there would be no money, there would be no money, they finally agreed to sit down and talk without money. And that brings us to the next date on the timeline, October 18th, 2011, where a settlement conference takes place between all the lawyers on the city side, including those from Fulbright, and all the lawyers on the developer side. And incidentally, some of the lawyers for the developer are here tonight in a gesture of good faith to... Okay, if not good faith, how about bravery?
But not the developer.
I think they live in Puerto Vallarta. In any event, following that settlement conference, I met again with representatives of the community and briefed them on the settlement discussions. On January 18th, 2012, the court, Judge Rosenthal, extended the deadlines in the case to accommodate the settlement process. And on February 26, 2012, the settlement documents were finalized. I know, I'm sorry? Why don't you give me a few more moments and you'll find out.
And then we're going to take questions through the microphone.
I do have to make it clear to you that an agreement has been entered into between the parties. It does not require the approval of City Council because there is no money changing hands. But there still is a basis for this community and this developer and this city to work together as this project unfolds. And that's a primary reason why we're here tonight. So let's look at the changes to this project, where it started in 2007, what was approved in 2009, and what is the basis for the settlement in 2012. I'm going to focus on 2012 because that's the project that will unfold as the developer goes forward with this. We are down to 115 net peak hour trips. There are 228 apartments, which is slightly larger than the April 4, 2009 project in terms of the number of apartments, but there are far fewer bedrooms than there were in that original project. It's now 21 stories instead of 23 stories. There will be a quality restaurant on the first floor with patio dining. We were adamant that there could be no fast food restaurants, which would increase traffic. There will be 4 luxury townhomes on Ashby. There will be a 15-passenger courtesy shuttle for the residents, running twice in the morning and twice in the afternoon to the Texas Medical Center. Now, I've seen in the blogs that this particular part of the agreement has been derided and ridiculed. We did not come by this feature lightly. This has been used in other cities to diminish the impact of traffic in projects such as this. It has been used successfully. We understand that the target audience for residents in this high-rise will be people that worked in the medical center. And we have every reason to believe, based on what we've researched in other cities, that this can work in diminishing the traffic impact to some extent. In addition, there will be an 8-foot fence, either of wood or masonry, that one cannot